It has been answered over and over and over. We do not hold up investigations for anything. It takes a long time to develop these cases, and to continue to ask that question is, in my mind, out of line.
That decision, the decision in 2010 not to charge, based on the evidence available at the time, was made by then Attorney General Corbett. Experience tells us, and the research tells us, that serial child molesters are significantly more likely than other offenders to continue their behavior, right? Even if they know that they're being investigated. So what happened in 2010? The decision, again, reasonable minds can differ about that decision whether to charge or not. But during the time that that they were considering the decision, and for several months thereafter, there really was no concerted effort to go find more victims, and that's puzzling in retrospect. Significant factor, sort of overarching factor as to why the investigation took as long as it did, was the failure to take certain steps earlier in the investigation that proved very valuable later on. Okay, what were those steps? The most significant of those steps, any one of which could have been taken in 2009 or 2010, were searching Sandusky's home, asking the local police about earlier investigations involving Sandusky. That's how they ended up getting the 1998 allegations or finding out about them, and questioning the local Children and Youth Service and the Second Mile about Sandusky as well. The major law enforcement problem with the use of search warrants in child sexual victimization cases is that they are not obtained soon enough. And that was certainly the case in the Sandusky investigation. The search of Sandusky's residence did not occur until June 2011. Right? That's more than 2 years after the case got to the Office of Attorney General, and as you'll see from the report, it's more than 18 months after searching was suggested by an investigator in the case. And when the search finally did happen, it uncovered unquestionably valuable evidence, including photographs of Sandusky victims and lists of Second Mile campers with asterisks next to some of their names, asterisks that later turned out to line up with people that Sandusky had victimized. Had the search been conducted in 2009 or 2010, investigators could have used those photographs and could have used the names to find victims much earlier than they did. Victim 1 described being abused in Sandusky's basement at his home and provided investigators with valuable and significant details about the layout of the home. If for no other reason, a search early on could have provided very useful corroboration for victim 1's story, which is exactly what some people were saying they needed before they could charge, and yet the search didn't happen. Search warrants are properly issued every day based on the word of a single victim. If the idea that a single victim wasn't enough to get probable cause, that would be astonishing.
This report also shows long periods of inexcusable, and by inexcusable I mean that even the parties involved couldn't offer an excuse for the delays, and delays that quite honestly are unfathomable to most of us. Why those delays took place, we don't know the answer to that. We don't know what was in their head. They describe it as there was also tactical errors that were made that could have moved this case 2 years sooner, at least 2 years sooner than it was. And those are inexplainable. For example, the 5-month delay between March of 2010 until November of 2010 as to why it sat on the presentment sat on someone's desk and there was no answer given. We don't know why that happened. Why was there inactivity or virtual inactivity for almost 18 months? Why wasn't a search warrant issued in the beginning? Why did it sit on someone's desk? And for that, we can't answer. The line prosecutor from the very beginning wanted, and as well as the agent and the troopers, wanted to conduct a search warrant, which was never done. It was declined, that it was rejected that they would be able to do a search warrant. It was the decision of the group to use a grand jury, and that's prosecutorial discretion. Some people would go that route. Some people wouldn't. But once you go that route, you have to use the tools of the grand jury that were offered. And as the report indicates, through long periods of 2009 and 2010, the grand jury resources were not used fully, as opposed to what happened in 2011. So it appears that the leadership of OAG, who was making the decisions, not the line prosecutor, had a real lack of urgency in taking Sandusky off of the streets, and also made some tactical errors that could have brought him off of the streets sooner.
You say the leadership, do you mean Tom Corbett?
Well, the leadership consisted of the chief of the criminal unit at the time, the chief of the criminal division at the time, the first deputy at the time, and the attorney general at the time.
The longer somebody like Jerry Sandusky is out and about, unouted to the public, the more risk he poses to the community. There are investigative steps that were not taken until 2011 that could have been taken in 2009. And I think for some of those steps, maybe there was a rationale for that. I mean, one of the rationales offered was, well, we didn't want to go to Penn State or to the local police department or Center County CYS, because if we did, then Penn State would find out about the investigation, and that might be bad. But on the other hand, there were decisions that were made that I think reasonable minds shouldn't differ about, like, for example, searching Sandusky's house. That could have happened in 2009, should have happened in 2009. So there are those sorts of decisions. There are also delays. Again, that March to August 2010 time period, not only was it a long time coming, the answer, but during that time, nobody was doing any investigation.
In the course of your investigation, did you become aware of any new victims who were alleging sexual abuse by Jerry Sandusky that happened after the case was transferred to the Office of Attorney General?
Yes, we do have two individuals who indicated that they were abused by Sandusky both in the fall of 2009. The Office of Attorney General received the case in March of 2009, and two individuals indicated that they were abused by Sandusky sexually in the fall of 2009. I'm not going to discuss the credibility of sexual abuse victims until they are found by a jury to be uncredible or incredible. The victims of sexual assault, when they tell us they're the victims of sexual assault, and unless we have anything to the contrary, we believe them.
The people who were involved in the investigation, the investigators who spoke to us, and the prosecutors, all of whom spoke to us, were aware of the risk. Right? They were aware that he might be continuing to offend, and they hoped that the fact that he was aware of the investigation would make that less likely. And they concluded that the risk of a failed prosecution was greater than the risk posed by that. So they did have those discussions.
Madam Attorney General, do you believe those victims who come forward in the fall of 2009 would not have been abused had this investigation gone more quickly?
If different steps were taken, if the course of action was taken that the search warrant would have been issued and executed, which could have been executed under seal right away, based upon the statements of victim one, then they would have found the corroborating evidence that they felt necessary for victim one. They also would have found the additional victims that they also felt necessary, would have made the case stronger. If that had happened, then Sandusky would have been charged earlier, no doubt.
The two people who come forward in the fall would not have been abused had they made the decision that you're now advocating.
Logically speaking, if different tactics were taken and a different route was chosen, and Sandusky was in jail with bail, by the way, if bail hadn't been that he was released on, with a cash amount, if he was in jail, of course, there wouldn't be more victims, of course. This factual report indicates that there are long periods of time where nothing happened. There are long periods of delays that we can't explain. This report also indicates factually that key investigative steps were not taken early on. For example, the search warrant. And because of that, the case took longer than it could have or should have. What this report also indicates, this factual, unbiased report indicates that the reasons put forth, Mr. Moulton's reasons put forth of, well, why did they take these certain tactics? Why did they use the grand jury? Why did they not issue the search warrant? Indicates that there wasn't that sense of urgency to get Sandusky off of the streets that other prosecutors may have had, and therefore chosen different courses of action.
Hold on. We're going to take two more questions.
Sorry, I can't hear
you. It will be available all day.
All stop with the Attorney General.
There were long periods of delays, and there were investigative steps that weren't taken that could have given not only a different result, but could have done it in less period of time. I would have done it. I would have issued a search warrant. So the question was, does the buck stop with the Attorney General? The buck always stops with the leader. But in this case, don't forget, there was no direct evidence. There was no email. There was no confession. There was no statement that indicated that the Attorney General at the time did it for political reasons. What it appeared to be is that there was a lack of urgency on the part of leadership. Why? We don't know that. That's going to be up to the public to decide.
It has been answered over and over and over. We do not hold up investigations for anything. It takes a long time to develop these cases, and to continue to ask that question is, in my mind, out of line.